Good afternoon, everyone. Thank you for joining us today for our webinar, Investigating Sexual Misconduct in Higher Education, Potential Pitfalls During Title IX Investigations, and How to Avoid Them. My name is Ashling and Ehrhardt. I've been an attorney here at Cohen Seglias for the past 15 years, and I'm also a member of the firm's Title IX group.
Hi, everyone. My name is Kate Gleason, and I'm also a member of the firm's Title IX group. Both Ashling and I are certified as a Level 1 Civil Rights Investigators by ATICSA, which stands for the Association of Title IX Administrators, and we've been conducting Title IX investigations at various universities and colleges for the past couple of years.
We are excited to bring this webinar to you today. Should you have any questions during the program, please ask them in the questions section of your GoToWebinar panel. We will address the questions as they come in and as time allows.
All right, so we'll get started here. I assume most people tuning into the webinar today are aware of Title IX and the language of Title IX, given the content of this webinar. But I wanted to provide some exact language as it is in the amendment to lay some groundwork and provide some background. Title IX is a federal civil rights law. It was passed as part of the Education Amendments of 1972, and the exact language reads, "No person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance."
It was really bare bones when it was enacted, and schools really didn't know how to respond to it and what to do with it. I know for myself, I was in college in the last century, and back in the 1990s, there was absolutely no mention of Title IX at the college that I went to. What about you, Kate? Did you have anything in this century?
Well, I started college in 2006, and I only ever really recall hearing about Title IX in my sports association. We were a D3 team, but we certainly didn't have a Title IX office and definitely no Title IX coordinator position or anything like that.
Well, I think that's important to point out that Title IX first began with girls requesting and demanding equal access to gyms, to athletic scholarships. And so a lot of people still today, when they think of Title IX, they really just think of it in the sports context. But the federal courts, once the act was enacted, they started defining what exactly Title IX was and expanded the scope of it to include sexual harassment as well as sexual assault. And, we've kind of gotten to where we are today. 2011, the Obama administration issued the Dear Colleague letter, which really defined and set forth what schools needed to do regarding sexual harassment, sexual assault, stalking, how schools needed to respond to that. There were the FAQs in 2014. But of course, we all know that in 2017, these were rescinded by the Trump administration by Betsy DeVos, who's currently the U.S. Secretary of Education. Since then, there have been the proposed formal regulations, as well as the comments which were submitted to that through January of 2019. And as we know, Kate, there were an unprecedented number of comments that were submitted during the comment period to these proposed formal regulations. Everyone who's anyone was saying that we were going to get the actual formal regs issued in September of 2019. I haven't seen them yet. Kate, have you?
I have not, but we are waiting with bated breath, as they say, so we'll see what comes out.
We'll let you know when Betsy DeVos gives us a call, but as for right now, we have heard nothing. And so we want to go next to we want to talk a little overview on the proposed changes. We have listed our top 10 principal changes in the proposed regs, and we're going to take you through them a little bit today before we get into the pitfalls and how to avoid them.
Right, and obviously we can't go through every single change, every single regulation, but again, these are just an isolation of what we think will be the top biggest changes for institutions conducting investigations.
So the first big change is the definition of sexual harassment. Currently, sexual harassment is defined as many different things, and there's really not one definition you can look to see how it's defined. It includes attempted or completed rape or sexual assault. It includes stalking, exploitation, exhibitionism, sexually based threats or abuse, dating violence, retaliation, quid pro quo. All of these things, which have, some of which have been borrowed from other areas of the law, have fallen into the definition of sexual harassment. In addition, schools have been defining what they think it means themselves.
Sure. So, the regulations for the first time, which is, a bit unprecedented, have provided a regulatory definition of what sexual harassment is under Title IX. So if the regulations pass as they're currently proposed, 3 types of behavior would be considered sexual harassment. And as Ashling mentioned, these definitions are taken from existing case law and regulations regarding sexual harassment. So the first definition here is quid pro quo harassment. You may know quid pro quo means this or that. This is a type of harassment where a person explicitly states or implies that an academic decision or perhaps the ability to participate in a school program or an activity would depend upon whether that person engages in conduct or activity of a sexual nature. So in short, it's conditioning educational benefits or services upon engaging in sexual conduct. The second definition would be unwelcome conduct on the basis of sex that is, quote, so severe, pervasive, and objectionably offensive that it effectively denies a person equal access to education. This particular definition comes directly from the 1999 Supreme Court case, Davis versus Monroe County Board of Education. And the third type of behavior in the proposed regs is sexual assault, which will include rape, fondling, incest, or statutory rape. And this particular definition is essentially identical to the definition provided in the Clery Act regulations, which is a federal statute requiring colleges and universities participating in federal financial aid programs to maintain and disclose campus crime statistics and security information. And I assume, a lot of you on the phone are gathering that sort of information and publishing it for your respective institutions.
The next big proposed change is what is actually going to trigger an investigation. Currently, the reporters at colleges and universities are deemed to be responsible employees. Now, this standard is it's a loose standard. Practically everyone on campus would be included within that standard. For example, resident assistants, professors. I mean, it's a big ambit of people from which to draw who are going to be reporters under the current state of affairs. Now, currently also, if a reporter has any notice or should have known about a Title IX investigation based upon what that student or faculty member told you, then that's going to be the trigger for an investigation to begin. We see a big change here in the proposed regs where a reporter is going to be more narrowly defined. It will not include professors or resident assistants. It's going to be a Title IX coordinator or an official with authority to take corrective action. So again, that's really going to change the scope of who is going to be required to report a Title IX investigation, a Title IX complaint. Also, actual knowledge of a Title IX investigation. It's really going to be, it's going to change because you can still move forward with an investigation. Let's say there is a person who comes forward but doesn't want to be identified, doesn't want to have to actually sign the written signed complaint that triggers the actual notice portion of the investigation requirement. You could still move forward with that investigation as long as the Title IX coordinator signs off on it. But the problem is going to come up if the party does not want to be identified at that live hearing later, which is also a new requirement, then you can't use any evidence from the investigation process. So it really does change the landscape of who is going to be able to report or required to report these investigations and how.
Yeah, so, along with changes as to who is going to report, jurisdiction is also going to change a little bit. Currently, students studying abroad in a university-sponsored or college-sponsored program can bring Title IX claims for incidents that occurred during that program, in a foreign country. However, there's some language in the proposed regulations that may indicate that the harassment must have been perpetrated against a person, quote, in the United States, end quote. So this could definitely affect harassment that is occurring during a school-sponsored study abroad program. These proposed regs do not prevent a school from initiating some sort of student conduct proceeding or perhaps offering supportive measures to a student who reports harassment abroad. However, the school's reporting and investigation obligation under Title IX may not necessarily be triggered with this new language.
I think it's interesting too. It really is going to come into play. How is a student defined within a particular college's policy? Is a student when they apply, when they're accepted, when they pay their deposit? Are they a student during winter break, during summer break? All of these things need to really be taken into consideration when spelling it out in the Code of Conduct and in the Title IX policy itself. The next big change in the proposed regulations is with respect to cross-examination. Currently, there is no requirement for cross-examination. In the proposed regs, there's a mandated right to cross-examination. So there's going to be a live hearing, and there will be questioning of both the reporting party as well as the responding party by the advisors or by the attorneys. It will not be done by the parties themselves. If this kind of makes the hair on the back of your head stand up, it can be not as horrific as one might think. It can be done remotely in separate rooms with the use of technology. So it'll be interesting to see how this plays out when the regs actually do come down and what the requirements will be. But there is a big change with respect to being able to cross-examine both the reporting party and the responding party in a live setting.
All right, another thing that's going to change is parties' access to evidence during investigation. Currently, at least in our experience, Title IX investigations are highly, highly confidential. For example, most institutions will issue notices or orders to the parties involved requiring that they keep this process confidential, that they don't speak to anybody about it, honestly, including each other and any outside parties or potential witnesses. So, the responding party in this situation generally has a bit of a passive role and may not necessarily pursue their own investigation or chase down their own evidence. I think this is because schools don't necessarily want witnesses talking to each other and planning or maybe coordinating their testimony or, their version of the events. However, under the proposed regulations, parties will not be restricted from discussing the allegations or gathering relevant evidence. There will be no, as we say, gag orders, restricting parties from discussing the allegations and the evidence. So both parties will really be permitted to conduct their own searches for evidence. And, as it is currently, responding parties are often in the dark. So I think the goal of these proposed regs is to make the process a little bit more open for both parties.
The next big change is the evidentiary standard. Currently, the current law allows for institutions to either use preponderance of the evidence or clear and convincing standard. Now, that's not going to change with the proposed regs. However, the big change is going to come in that the requirement under the proposed regs says that the school has to be consistent with its other codes of conduct. So if a code of conduct for faculty tenure revocation at your school says you have to use the clear and convincing standard, then you must also use that standard in a Title IX investigation. I also just want to take a step back and, lawyers talk about these standards like everybody knows them. Preponderance of the evidence, what does that actually mean? To me, it means it's more likely than not. Someone once described this standard to me as 50% plus a feather. So it's not a big jump. It's not a big burden to prove, Kate. It's a pretty low standard as far as standards come. The clear and convincing standard, to meet that, the evidence has to be highly and substantially more probable to be true than not. And in addition to that requirement, you have to have a firm conviction or belief in its factuality. So the evidence there has to be substantially greater than a 50% likelihood of being true. To me, I think of that kind of along the lines of maybe if I were going to put a percentage on it, it would be 75% or 80% more likely than not that it happened. So those are kind of the two standards and how they play out. But again, the change that is going to come down if the proposed regulations are in fact enacted, it's going to be, you're really going to have to look at all of the standards in effect at your particular institution of higher education and make sure that if you have any clear and convincing standards at all, either in the employment context or in any context, that is going to have to be what you use in your Title IX investigations.
All right, and before I go on to the next change, we did get a question, so popping back to cross-examination really quickly. The question is, what if one of the parties doesn't want to have an advisor or an attorney with them, and will they be able to ask the questions themselves? The answer to that is no. If a cross-examination is going to happen at the live hearing, the advisor, or which could be an attorney, will be asking the questions. And another thing to be interesting to see is whether, when the regs come out, whether parties will be able to waive the option to cross-examine. It's a little bit unclear right now. All right, so moving on to the next big change. The next big change is to the investigator model that's used. Currently, what's known as a single investigator model is okay. And that means that, one person can gather the facts, make an investigation, and then prepare the responsibility determination. And as we've discussed, this does not require schools to provide for live hearings. Some schools may, depends on their policy. But under the proposed regulations, once the investigation is concluded, a written determination is prepared and sent to the parties with the finding of responsibility or non-responsibility. And that obviously includes the facts and the evidence on which that determination is based. But the biggest change here is that determination, the final determination, must be made by a decision maker who is not the same person as the Title IX coordinator or an investigator. So under the proposed regs, the single investigator model, which many institutions currently use, would be prohibited.
And I'd like to take a moment, Kate, if I may, to talk about the two investigator model that we use and that we have found that is very efficient and and it really works well with what we've set up. So we partner with an investigator who has former law enforcement experience, who is also a TICSA certified and has received trauma-informed training. So when schools hire us to conduct Title IX investigations, there are two people always involved. So there's an attorney and there's the former law enforcement officer, who both of us are listening. We're asking the questions. We're involved with the writing of the report. And I think it's a nice model, Kate, for several reasons. The first is that it's always helpful to have two people in a room. Two people will take away and bring to the table their different experiences and what they're noticing. And I think specifically in our model, to have the person, the investigator who's got the lots of training in witnessing, interviewing witnesses throughout the years, he picks up on, body language, other signs that we may not pick up on ourselves. And so I feel that our model that we have, at our firm and that several schools have hired us to do and to implement does work really well.
Yeah, I find it's really helpful to have someone to bounce ideas off, after the interview and kind of reconvene and talk about what exactly happened. And I'd say the investigator we work with at least picks up on a lot of stuff that I'm just not trained to recognize or pick up on. Mm-hmm. All right, so the next change we want to talk about is the provision of the report and the various evidence gathered in the investigation for the parties to review. So currently, there's no requirement that parties have the opportunity to do that, review this written draft report prior to a final determination. Some schools may currently do this. I personally, none of the universities or colleges I work with technically tend to do that. But under the proposed regulations, both parties are going to have access to all of the facts and the evidence collected by the investigator. So they're going to get copies of that draft report before final determination and have an opportunity to comment on it and provide a response. And again, as mentioned earlier, the parties will have that opportunity to participate in a live hearing where they can cross-examine each other based on the evidence provided in the draft report.
Right. The next big change in the proposed regulations is in the form of mediation. Currently, the parties have to go through a formal process for all sexual assault claims. There is no option for an informal resolution for sexual assault claims. So the proposed regulations they offer this informal proceeding, including mediation. However, both parties have to give written consent. So it's really going to be interesting to see how this plays out. There are not many details on how mediation would work in the proposed regs, but this is a very significant difference, and especially for resources for the college, for the university itself. If parties are going to be amenable to engaging in something that's much less costly than it otherwise would be to do a full-fledged investigation, that this is going to be another option, and hopefully one that's not as taxing and arduous for the parties.
So next I want to talk about what's called a safe harbor provision that's in the proposed regulations. And I don't want to get too into the weeds on this, but I'll just give a quick explanation. So currently there's no safe harbor for universities when facing an allegation of improperly handling a Title IX claim. So under the proposed regulations, there will be a safe harbor. So this is, as I said, in reference to a college or a university being subject to a complaint, most likely by a reporting party, that the school did not respond properly to an allegation of sexual harassment. And the school can be liable under Title IX if there's a demonstration that the school acted with what's known as deliberate indifference. So that's, the school's response was clearly unreasonable in light of the known circumstances and the steps they took. So under the proposed regs, a school must investigate every formal complaint. And if while investigating such a formal complaint, the school can demonstrate that it followed procedures consistent with the proposed regulations, then that school is going to have what's known as a safe harbor against a finding of deliberate indifference, and they will not found to have discriminated under Title IX. There's also another option when there's no formal complaint filed. Say the reporting party doesn't want to go ahead with a formal investigation. The school still has to do something in order to receive this safe harbor. This would usually include offering supportive measures like perhaps class reassignments, housing relocations, parking in a new area, different area. So if the school provides these supportive measures in the absence of actual formal investigation, it's also protected from that finding of deliberate indifference. And just one, practical tip, the school should inform the reporting party of their right to file a formal complaint when they offer these supportive measures, just to, keep everything in writing and keep a record of everything.
Now, Kate, where would a student file a formal complaint?
Students generally file complaints in the court, so that would be the federal district court in the location of wherever the school is. So, for example, if it was in Philadelphia, it would be in the Eastern District of Pennsylvania.
And what about OCR?
That is also an option, and I think we're going to get a little bit into the different remedies for sexual harassment claims a little bit further down the line, so everyone understands how Title IX procedures follow along concurrently with criminal procedures and OCR.
And by OCR, of course, we mean the Office of Civil Rights.
I apologize.
The goal of any Title IX investigation, what is it? To provide a prompt, impartial, adequate, and reliable outcome. If every process can guarantee these four principles, then the defense of opportunity for access to educational programs can be ensured. The problem is, Kate, how do we do that? These four words seem pretty easy and basic, but how will this affect everyone? How will the new regulations affect this? Who's involved, Kate?
Right. So, if I was giving this particular presentation in person in a room, I would, name a few positions and see who you have in the room. But I can actually tell a little bit from the list of attendees. I see we have a variety of people tuning in today, a big bulk of whom are Title IX coordinators, as well as human resource directors, some housing directors, a couple vice presidents, some deans, campus safety, as well as a few fellow attorneys. So these proposed regs are going to affect everyone I just mentioned, including obviously, the institutions, colleges, and universities. And again, this will also affect K through 12 education, but Ashling and I, our expertise is mainly focused on colleges and universities. But among the other affected parties would be obviously the reporting party and responding parties, their attorneys and or their advisors, as well as Title IX investigators, Title IX coordinators.
Right, so you get a complaint or an allegation of sexual misconduct at your college or university, and you know you've got to do an investigation. What does that mean? We're going to go into that a little bit more in depth, but first we're going to do a little investigation to make sure that a bigger investigation is warranted. If indeed the bigger investigation is warranted, you're going to be conducting your interviews, preparing summaries of those interviews, sending draft summaries to the witnesses, and then finalizing those summaries. You're going to review the policy, and this really is important, and honestly, it should be the first thing you do when you get notice of a particular violation of any policy. So you're going to want to look at, are they alleging sexual assault? Are they alleging sexual harassment? What are they alleging? You know, they may not know the terms that are set forth in your policy, and so you really want to gather as many facts as you can to learn which violations or which sections of the policy there is a possible violation of. So you're going to apply the policy to the facts at hand, and then you're going to write your report.
All right, so now we're going to get into the fun stuff. I'm sure big reason of why a lot of you are tuning in today. So, top 10 pitfalls.
I wanted to play the Dave Letterman top 10 music, but we didn't think it would carry over well. So just picture in your head, all you Dave Letterman fans from long ago, the top 10 reasons. Here we go.
All right. So, as Ashley and I mentioned, we've been conducting these investigations and writing reports for a couple of years now. So we've encountered a large number of different types of cases, and so I think we're, in a position to provide some real world advice and examples of issues we've encountered, and definitely encourage you guys to ask questions if you have any.
Pitfall number 1, dun 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 dun, failing to advise reporting parties about options available to them or influencing them to choose one process over another. Kate, this is a big pet peeve of mine. I have seen it many times in investigations, and in one particular case stands out for me that took place a couple of years ago. But I had it was an allegation of sexual assault, and within the ambit of that investigation, one of the people that we interviewed was a collegiate coach for the sport involved, and the coach came in during his interview. He said, "Yeah, I accompanied the person, the reporting party, when she came into the Title IX office, and I was surprised at how the options were presented to her." He said, the option of going down the criminal path or the Title IX investigation path were spoken about and offered, but the way in which they were offered was concerning to him. So, it was his opinion that the criminal path was made to seem like it was going to take years and just drag on forever. And that, this poor reporting party would just be dragged through the mud and years of her life would be wasted in proceeding forward with a criminal complaint. Whereas the Title IX investigation, if she went that route, that was kind of seen like she was told it was going to be done within a few weeks, and it was really painted in a much better light. And so for all of you Title IX directors, coordinators, anybody who's meeting with a witness of a reporting party for the first time, you really want to present an unbiased option to the people coming to you for guidance. They're looking to you. This is a scary and intimidating time for them, and you need to present them with every option that they have. You need to present them with the criminal option. You need to present them with the Title IX investigation. Yes, you can discuss the pros and cons of each, absolutely, but in no way, shape, or form should you be telling them or trying to influence them, to choose one way or the other. And I think it's also important to let them know that they can choose both. They can proceed with a criminal complaint as well as the Title IX investigation. So you really need to to present their options to them in an unbiased manner. I think it's also important to let the reporting party know, especially, that should they proceed with a Title IX investigation, if there is a concurrent criminal investigation going on, or if there is a OCR case that's going on, the Title IX case keeps going. And I think, that's important for all of us involved to be aware. There's no stopping for the criminal case. There's no stopping for an OCR case. The Title IX case is going to go forward uninterrupted.
Yep. All right, so pitfall number 2. So I think a big failure is when an investigator immediately assumes that, a big investigation is going to go forward and they don't perform what's known as an initial investigation to determine whether that full investigation is really necessary. It's important to first determine the extent of investigation. So I had a case a few years ago where a Title IX office was receiving a lot of anonymous tips from their hotline that a particular sports team was experiencing a number of sexual harassment issues, both between team members themselves, incidents involving coaches and team members combined. So when the Title IX director first received these complaints, he contacted me and we discussed how to approach the case. He was able to suggest some key witnesses to interview, so we decided, before going with a full-blown investigation, to conduct a few select interviews of former and current team members and former and current coaches. So interestingly, what ended up happening was after we conducted those few interviews, we determined that the anonymous tips were basically unfounded and that there was no need to engage in a formal investigation. And I think this is a really important step because, if you go straight to a full-blown investigation, there's huge costs involved as well as a long time and your resources are being used up. So I think it's really important to determine whether you need that big investigation. And in fact, under the proposed regulations, there has to be reasonable cause to believe a full investigation is needed. So if you perform this, little initial investigation first, you can really figure that out.
Pitfall number 3, cue scary music. Failing to give proper notice of the allegations to the responding party. I mean, the responding party needs to know who's accusing them. What are they being accused of? What is it out there, that they need to know so that they can properly prepare for their witness interview? I was involved in a case where we got involved after the fact, but once we got involved in this case, I came to learn that the allegations were against a collegiate coach, and he went into his interview as the responding party with absolutely no idea who was accusing him or what he was being accused of. So how could that coach, who's sitting there with his union representative, how could he possibly have meaningfully prepared for that interview? He could not. So it really is important to provide sufficient detail of the allegations to allow the parties to meaningfully prepare. I think, too, it's interesting. I had a case somewhat more recently where once the initial notice was sent to the responding party, and we had conducted the interviews of both the reporting party as well as all of the reporting party witnesses. And before the scheduled interview for the responding party reached out to me and said, listen, I know that I've been given notice of the allegations, and I believed that she had been given notice of everything in accordance with what she should have been given. However, she asked for, more definitive statement on what the precise conduct was that formed the foundation of the alleged violations. And so at that point, when I received the request, I went to the Title IX coordinator and said, listen, this is what's happening. This is the request from the responding party. How do we want to address this? And, kudos to this particular Title IX coordinator. I think she has a good mindset of wanting to really, keep the parties happy and to address their concerns throughout the process. And that's going to change and vary, with every case that you have. But here, we were able to provide the responding party with a more definitive statement of the precise conduct that formed the foundation of the alleged violation against her. And so she came to her interview feeling that she was able to more meaningfully prepare for it and to better participate in the process, which is what, of course, we all want. The last thing I would say is to make sure that when you are giving notice of the allegations to the responding parties and that you're scheduling interviews, or for any witness, that you really give them enough notice in advance in which to prepare.
Yeah, that's very important. And, I recently did a case this summer where, it was very important to get people pretty advanced notice since, when kids aren't in school, they're usually in their home state or whatever, and they may need, to arrange travel. If they're bringing an advisor, they'll have to arrange how their advisor will get there. So advance notice is very, very important. All right, pitfall number 4. Dun, dun, dun. So I think there's a temptation sometimes to focus on the reporting party and perhaps not the responding party. Maybe that's because, the reporting party is the one making the initial report and is the one that is, alleging that something terrible has happened to them. I think it's, however, really important to know that the focus of the investigation should really be on both parties. And as an investigator, we need to ensure that both their needs are being met and their concerns are being addressed. A brief case study, I was investigating a case involving stalking on a college campus, and in this particular case, by the time I was called in to conduct the investigation, certain supportive measures had already been provided to the responding party, which is certainly a proper thing to do. So, for example, the responding party received a very detailed set of instructions about where he could go on campus. And, even at what time. So this was so detailed, it was down even to the particular hallways and stairwells that he could use in certain buildings, parking lots that he could park in. So, I think supportive measures are definitely necessary, especially, in a stalking case. I think it's important to provide these measures keeping both parties in mind. Unfortunately, in my case, the responding party missed out on a number of activities on campus, including presentations that were directly related to his major because of the supportive measures in place. He was not allowed to physically be in the same area. And I could see that it was weighing on him mentally a little bit because, every time he had to go somewhere, he felt like he had to call the Title IX office and say, hey, can I actually go to this spot? And sometimes they would say no. And, I think it's important to keep in mind that there hasn't been a responsibility determination made yet. And interviews honestly haven't even been conducted, so it's important to provide supportive measures in a way that doesn't negatively affect either the reporting or the responding party.
Yeah, I think that you raise a good point, Kate, and also, these are kids. Some of these kids have never been away from home. They're 18, 19 years old. They're young and impressionable, and this is a scary process. And so it really is our job and in our rules, whatever they may be throughout this process, to protect both parties' rights. I remember being involved in a case where it involved a coach at a particular college, and the allegations against him were for sexual harassment, for inappropriate touching or hugging his collegiate athletes when they felt uncomfortable. And so one of the people that I interviewed was I believe it was the assistant athletic director. And when I interviewed her, she said, "Oh yeah, he makes me feel uncomfortable too, but I really never thought about how it would affect a college student or a college woman in that setting." I'm like, that's your job. You're the assistant athletic director. We need to be thinking about this and looking out for these kids. So reporting party, responding party, the focus really needs to be on both. Pitfall number 5, failing to properly train investigators. I think really this pitfall stems and piggybacks off of the one we just talked about. There needs to be a balance in training. It can't be all victim-oriented. So the training needs to be addressed from both perspectives of the reporting party as well as the responding party. Don't make a responsibility decision before applying the facts to the policy. the president of the college may want to be involved in the process, in the Title IX process. But it's really not he or she is not a great option because, if he or she is not properly trained, you're not going to get, the best bang for your buck as far as his or her participation in the process. You also want to be aware of improper influences which can impact a decision. Athletics plays such a huge role on campuses, social media, the power and position, that some people hold, and how that can affect a Title IX investigation. You really want to be conscious of that. You want to follow the process and the policy no matter what the external pressure is.
Yeah, definitely. And I think this also has a big effect when there's sports teams involved because athletics are so important on college campuses. So it's important to keep that external pressure balanced. All right, so on to pitfall number 6. Now, I know a lot of listeners right now are Title IX coordinators, and I don't want to scare you, but in truth, you have a huge amount of responsibility and oversight in this process. So, a big pitfall would be failing to properly supervise an investigation. As a Title IX coordinator, you're responsible for overseeing that investigation from the initial report in the very beginning to the very end. So, for example, in terms of initiating an investigation, you're responsible for assigning cases out to investigators. So things to consider would be how many cases that investigator or investigators may already have. So if you've got one investigator and he's got 20 cases, you may need to think about hiring either additional investigators or perhaps even an outside counselor or outside investigators. You're supervising the investigations as they're occurring as well, which includes working closely with the investigators, whether they be, hired by you in your office or whether they be outside of your office. You'll be working with them to schedule interviews, contact witnesses. Another thing is, before the investigation even begins, as I kind of already talked about, you may be issuing supportive actions and corrective measures. So it may be responsible to get maybe a responsible action to get a little bit of information about the case so that you are able to, implement those supportive actions and corrective measures. So lastly, a bit of practical advice is to really keep track of every step of this process. Write it down, write memorandums and reports. So that will help create an institutional memory of how these things are developed and dealt with. And, for the next Title IX coordinator, should you move on, they'll have a record of how things are done and how things go. And I think that's really important.
Definitely. Pitfall number 7. Dun, 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 dun. Failing to strategize the investigation. There really is, an important responsibility to, once you get a case in, every case is so different. You can't just have a checklist and check off every box and then say, okay, I'm done with this investigation. You really need to, as investigators, the investigators or investigator, they really need to sit down with the Title IX director and develop a roadmap for how the investigation is going to play out. First, is a formal investigation even necessary, as we discussed a little bit already? Is that appropriate at all? You need to determine who has the relevant information. Who are you going to be interviewing as part of the process? Not only who will the witnesses be, but what about the order of the witnesses? That really is a strategic decision. We had a case a while back now where it involved a particular collegiate team, and one of the decisions to be made was, we don't want the players talking to one another once we start interviewing 1, 2, 3. Do we just bring the entire team in, take away their phones, and then call them into a room, got a couple investigators in different rooms and talk to them that way? So, we did not end up doing that. But it's good to think outside the box with different ideas that can really move the case forward in the best way. You also want to think about the order in which you conduct the interviews and why. We typically will interview the reporting party first, and then at the end of that interview, we will ask her or him to give us a list of all of the witnesses that he or she would like us to interview. And so, you may get a list. I've gotten 10, 20 names on a list. Do you have to interview all 20, Kate?
I mean, there may be a situation where you do need to, interview all 20, but it may be that witnesses 4, 5, 6, and 7 all have the same perspective. They're going to offer the same evidence. Maybe then you only interview one of them. So.
Yeah, and I think it's good to ask the reporting party why you want us to interview each of these people. What are we going to learn from speaking with these particular witnesses? And again, with these young kids, a lot of their witnesses are mom and dad. They're frequently on lists.
I've spoken to many parents.
Yeah. So I tend to think sometimes it's not so efficient to speak to parents. But honestly, in one case, I learned the best tidbit of knowledge from speaking to a parent about just how anxious and afraid a particular reporting party was to even go into a store and buy anything. And so, for me, speaking to that parent really gave me a new insight into who my reporting party was. And so, you really want to strategize about who you're going to be interviewing and why. So we've got the reporting party. You would interview then the reporting party witnesses. Then you're going to bring in the responding party. Typically, and then ask the responding party who he or she would like you to interview next. And again, you go through the same analysis as to, with his or her witnesses, who are you going to interview and why?
All right, so on to number 8. This pitfall relates to failing to thoroughly investigate allegations. And I think this will relate to a question I just got about training Title IX investigators as well as campus police and or security. So I'll get to that in a little bit. So it's really important when you're investigating an allegation to really gather all the available evidence. So that includes looking in a large variety of places. Like Ashling and I discussed earlier, college and university life is a far more different form than when we went. I mean, technology has really it's completely different than we went to college. Like, for example, I didn't even have a smartphone in college, and I'm pretty sure Ashling didn't have
no. In the last century.
So, types of evidence I typically ask for would be text messages and any other form of instant messaging, like Snapchat, Facebook Messenger, GChat, if anyone still uses that, as well as other forms of social media like Instagram posts, Facebook posts, including photographs. And I think sometimes students are hesitant to provide these things, but sometimes they'll easily just send me screenshots of all the relevant text messages, and I think those can be very important. They're maybe closer in time to an incident than what you're hearing immediately, so I think it's really important to not forget to ask for these things. Further, when dealing with a case involving physical assault, like a rape, you're going to want to get to ask at least for medical records. And if the witness and or the reporting party is comfortable providing those things, they will do so, and they can be incredibly valuable. Another source of important evidence would be video surveillance. And I think this relates a little bit to the question about training police and or security. Obviously, Ashling and I aren't too involved with how your investigators or your Title IX coordinators and general staff are trained, but I think it's really important for the Title IX office to have some sort of relationship or understanding with public safety or whoever might maintain a video surveillance system about what is going to happen when a Title IX report is made. Obviously, most campuses have pretty sophisticated video surveillance systems these days. So what that means, though, is that, if everything's being recorded, that's great, but a lot of systems are set to override that video footage in maybe 30 days, 60 days, 90 days. So it's really crucial to isolate the video evidence as soon as possible, potentially even before an investigation begins. I've had a few cases where, unfortunately, there wasn't any sort of understanding about how the system worked or who would be responsible for pulling that video, and the video was lost, where it could have been really, really helpful. One last type of evidence I've recently begun to ask for, and Ashling always makes fun of me, but it's GPS evidence. So I think we all know cell phones these days unless you turn it off, track everyone's movement. And this data is available in a Google Maps timeline that can help corroborate testimony about timing and location, and I think which in turn helps determine the credibility of a witness. If you have a witness saying she was in one dorm but was actually in another dorm, or you can look at her cell phone and say, hey, actually you weren't here, or you were you haven't moved in 4 hours, maybe were you asleep? It's very important, and if they're willing to give it to you, and I have had students be perfectly willing to hand over their cell phone and show me their map. So
Amazing.
it can be super helpful.
You don't get it unless you ask. I think another thing too, Kate, that I just wanted to point out is, as far as interviewing witnesses, you don't be afraid to re-interview a witness.
Oh, yes.
So because we typically interview the reporting party first, if at the very end, you're left with a lot of questions that you think would be helpful for the reporting party to respond to, you want to bring that person in. Now, you have to weigh the benefit, versus the detriment of doing that. Of course, there is the fear of re-traumatizing that person. But at the end of the day, if you really think that for your report to be complete and accurate and thorough, that you need to get answers to those questions, don't be afraid to bring in a witness for a second time.
Yeah, that's a really good point. I mean, again, you want to be careful of re-traumatization, but quite frankly, if your report is going to be lacking, there's going to be holes in your report, and you think those holes could be solved by bringing someone back in to address a new allegation, I think it's really important that you do, and may even, you cover yourself in case there's some sort of allegation later down the road that the report wasn't complete or that the determination was wrong.
Yes. All right, pitfall number 9, numero 9, failing to prepare for each interview. You got to prepare, folks. You've got to have your interview questions or an outline all ready in advance. But I want to encourage you, sometimes, if you're not trained in interviewing, or if you haven't done this a lot, you kind of get stuck. You're looking at your outline and you can't veer off of it. You really have to listen to what each witness is telling you and respond in kind. So if a witness is, answering your question but giving you another tidbit of information that you didn't expect to get, you need to follow up on that. Don't be afraid to get off of that outline or off of those questions to gain other valuable information. You also want to consider the location of your interviews. Where are they being conducted? Is it going to, again, these students that are coming in some of them are terrified to come in and speak to you. So is it a place where they're going to feel, welcome, invited, at least not terrified or traumatized to enter the building? Is it a safe place? You also want to think about how you're scheduling your interviews. You don't want witnesses to be sitting in the waiting room of wherever you're gathering your interviewees, and talking to one another or overlapping in any way. So you really want to give careful consideration to who you're interviewing and when and where. I also think, too, it's so important as the neutral fact finders in an investigation to remember that these are interviews, not interrogations. We have no side. Our only side in this process is the integrity of the process, nothing else. So, you really don't want to be asking too many why questions that make someone feel that, they shouldn't have done what they did. On the other hand, too, you want to be careful not to be too empathetic. You really don't, as the person asking the questions and interviewing, you do not want your emotions to take over the interview. The role of the advisor or the counseling center is that their role is to empathize. Your role is, to be courteous and to obviously respect them, to have tissues, to have mints or chocolates, something, to let them know that you care and that you're listening. But you're not going to be saying, I'm so sorry that happened to you, or that's too bad. You really want to steer clear of language like that, because if you appear too empathetic, what's the end result, Kate?
They're going to be pretty upset when your report finds against them. And
yeah,
I have to say, it's really hard for me. I mean, when you have a party sitting across from you crying and crying and crying, it's really hard not to say, I'm sorry, or, that I'm so sorry this happened to you. Yeah. So I understand it being difficult, but you do have to be very cautious.
Yeah, just remember your role. And again, your role is to ensure the integrity of the process.
All right, we're nearing the end here. So this is going to be a big one. Last pitfall, number 10, failing to get the most out of your interviews. And I think this really piggybacks off the last couple we've talked about in preparing for interviews and making sure you're thoroughly investigating allegations. So the first thing I'd like to talk about is the demeanor of investigators. So personally, I always like to start out with some background about myself and my co-investigator when I'm first starting out on an interview. I'll ask about the witness's background, develop a rapport, and really, thank them for being there. Obviously, these are difficult topics at times, and it does take some amount of courage to, come in and talk to complete strangers usually about these things. So along with that, I try to maintain good eye contact and use what, are known as active listening skills, like nodding and prompting the witness to keep talking, and you said this, and, you balance off their next question and just really dovetail off their next question, their response. So in terms of interacting with the witnesses, we generally start by explaining our role, talking about the fact that we're going to be using potentially uncomfortable language, talking about sensitive issues. Like Ashling said, we usually have Kleenex available. I like to provide mints. I think it's important to make the witnesses really comfortable because you're talking about super difficult topics. I think it's also very, very important to remind students, I would say honestly, probably as you're scheduling the interview and again during the interview, about your school's amnesty policy.
Yeah.
Some students, if they're underage in terms of drinking, they're hesitant to be honest about things like drinking and obviously illegal drugs for any age. It's an uncomfortable topic, but the reality is that it happens at college and at university. So a lot of students are hesitant to come forward and talk about that kind of thing. So I think it's important to remind them that they're not going to get in trouble for this, and it's important to describe everything as it happened as they can remember because it's very important for the investigation. Along with that, I think it is important to remember that trauma can impact memory. So there may not always be a linear account of what happened, but at the same time, it's still really important to drill down on the timeline and the details that the witness can remember. The last pitfall is failing to define the terms used by witnesses. I'm not that far removed from college, but I'm far enough that I'm starting to not recognize things that people are saying. So obviously language changes over time. There's new terms invented. New definitions can be assigned to old terms. For example, I always like to clarify what hooking up means. In my experience, it can mean anything from just kissing to actual sexual intercourse. Another new one Ashley and I discovered was Netflix and chill, which if you're not familiar with it, it's a colloquial term for having sex, not coming over to watch a movie and hang out as,
which is what I thought.
So, I think it's really important to, and that kind of goes along with following up, dovetailing on a witness's report. If you say, like, they say something you don't understand, don't be afraid to get in there and be like, when you say this, what do you mean? And often it's something completely different than what I had expected. Last, and I think this kind of relates to what we said about coming back for re-interviewing. I think it's important at the end of the interview to let the witness know that there's potential they might be called back for a follow-up. So that way, if you need to re-interview someone, it doesn't come as a shock or a surprise to them, and that can kind of go with lowering the re-traumatization possibility. All right.
That's really it. If we have any questions, Kate, we can certainly answer those now. We thank you so much for attending the webinar today. This was our first webinar on this topic, so if you liked it, give us a shout out. If you hated it, keep quiet. No, we'd love to know what we can do to make it better. And if there are any other topics that you would like for us to do in a future webinar, we would love to do that as well. We are also willing to come to your school. You can gather up your Title IX group, all of your investigators, anyone who's going to be involved or is involved currently in your Title IX process at your school. We would be happy to come and give a free seminar on this topic or any topics of your choice to really to get your Title IX group.
Some scenarios would be cool. That would be something we'd certainly be interested. Obviously we only had an hour today, so didn't want to get too into the weeds, but we'd be very happy to come to your school and do a presentation for you, do some interaction and hypotheticals.
And I'm sure once Betsy DeVos gives us the final regs, there will be another webinar about that and many more questions stemming from that. So thank you so much for joining us here today, and we hope you have a great day.
Thanks so much.
Bye-bye.